Hello, everyone. Welcome to another edition of Employment Law Q&A. My name is Alex Lucifero. I am the managing partner of Samfiru Tumarkin's Ottawa office. I am an employment lawyer. I also practice disability insurance law as well. And welcome to another Q&A. Our firm hosts these Q&As throughout the week. It's an opportunity to get your questions answered, to get your workplace issues resolved, whether you are dealing with an employment issue or a disability insurance issue. Now is your opportunity to speak with an employment lawyer, speak with a disability insurance lawyer, and get those questions answered right here, right now, live on whichever platform you are using. And so to those of you watching, do not be shy, do not be bashful. Please go ahead and ask your questions. There are no bad questions. Anything under the employment law sun, whether it's to do with maybe a boss that is not treating you well, or perhaps your employer is changing the terms of your employment. Something is changing at work and you want to know whether your employer can do that to you or not. Maybe you've been let go from your job and you've been offered a severance package. Really, whatever your question is, if it has to do with your workplace, now is the time to ask those questions. Before we get into our show today, a couple of pieces of contact information that I want to share. If you want to get a hold of us, not on a live stream, but at the office, go ahead and email us. The first piece of contact information, our email address, help@employmentlawyer.ca. You'll see it on the screen, help@employmentlawyer.ca. Send us a brief email with respect to your situation, and I promise someone will get back to you. That is where you should be reaching us. You can also reach us on our website, of course. Employmentlawyer.ca is the website address. We have a ton of resources on the website. News, video clips, articles, blog posts, a bunch of information with respect to really any issue under the employment law sphere. Again, if you have questions, if you have concerns, don't be shy. Visit our website, employmentlawyer.ca. You can also find, of course, our contact information on that website for our various offices, for all of our employment lawyers. You can find all of that information there. Another nifty tool that you can actually use, again, if you're dealing with a situation at work and you're not sure exactly whether there's any legal recourse there, pocketemploymentlawyer.ca. Is another tool that you can use. Again, that's pocketemploymentlawyer.ca. You answer a couple of questions. It could be about severance. It could be about layoffs, temporary layoffs at work. Could be about being terminated for cause, meaning without severance. Answer a few questions, describe your situation, and out will come an answer, pointing you in the right direction. Again, guys, just a couple of resources that you can use. Our email address, our website, pocketemploymentlawyer.ca. If you want to get a hold of us confidentially, reach out, find us through those resources, and we would be more than happy to answer any questions you have and ultimately help you resolve your workplace problem. Again, that is what we are here for primarily. Let's get to the questions, guys. I already see a couple coming through on YouTube. So let's get started. And if there are any lulls in the questions over the course of the half an hour, I have a couple of things I also wanted to discuss with our viewers, but questions take priority always, always, always. So let's get to those without any further delay. All right, Joe on YouTube asks, is it okay for an employer to berate an employee, a co-op student, in front of staff? Joe, it's not okay for an employer to berate any kind of employee. I don't care whether they're a student or a 25-year senior employee. All employees must be treated with respect and dignity in the workplace. It's not just me saying that. I'm not simply making that up. In Ontario and throughout Canada as well, there are quite strict laws in place under health and safety legislation and under our human rights codes that require employers to treat employees with respect. If your employer is yelling at you in front of other employees, that is effectively harassment, and harassment cannot be tolerated in the workplace. So, Joe, very simply, the answer is no. An employer cannot berate an employee, again, regardless of whether maybe a co-op student or any other form of employee. full stop, particularly if that's in front of staff as well. Now, what does an employee do in a situation like that? Well, as an employee, you have a couple of different options. If this was another employee in the workplace, or perhaps even your manager, you can file a complaint with your human resources department if your employer has such a department, or you should speak to a level of upper management with respect to the situation. In other words, report the incident. By reporting the incident to your employer, again, whether that's an HR department or someone else in management, it triggers an obligation on the employer to investigate the allegation. And so, in a case like this, Joe, your employer would actually have to investigate the complaint and decide ultimately what recourse needs to be taken. Perhaps that particular employee needs to be punished. Perhaps there's a situation where the employee would be entitled to some form of recourse in the course of their employment. And so that is step number one. Your employer should act, but the only trigger that requires it to act is the reporting of the incident, which is ultimately on the employee to do. Now, if you work in a small mom and pop shop, and for example, the owner of the company is the one that is doing the berating and the harassing, well, then effectively there is no one else that you can report this to. That is when you have to look for help outside of that particular employer and either discuss your concerns with an employment lawyer such as ourselves, or perhaps with the Ministry of Labor. Although I would caution our viewers out there, the Ministry of Labor oftentimes is the wrong place to go for employment law advice. Oftentimes they will get aspects of employment law wrong. And so, again, if you're in one of those situations, Joe, where the person that is doing the harassing in your workplace is the owner of the company or the president of the company, and there is no alternative option, nobody else to speak to, you should be speaking with an employment lawyer right away. Do not wait. You can't deal with this issue months or certainly years from now. You want to act right away in that situation. And again, I'll reiterate, no employees should be subject to abuse or harassment in the workplace, regardless of the status of that employee. All right, Jordan asks, thanks for your question, Jordan. Given that there was an exception of maternity for the earning requirement for programs such as CERB, how much would it cost to fight the government to allow exceptions where people would have the earnings if it were not for an ICBC or WCB claim? My view is that it could fall under disability rights. Interesting question, Jordan, perhaps less of an employment law question and more of a policy question with respect to government's policies, and particularly Service Canada in the case of employment insurance and CERB. For those of you who maybe aren't quite catching on, what Jordan is referring to is effectively, unless you worked let's say, a certain number of hours, you would not qualify for either employment insurance in Canada or what's known as CERB, which is effectively a kind of COVID temporary job loss benefit. And so what Jordan is pointing out, and I believe correctly so, and this did come up, I believe it would have been in 2020, so a couple of years ago now when the CERB first started, is that if you didn't have enough hours in the bank, so to speak, because perhaps you were on a medical leave of absence, or perhaps you were on maternity leave, you would not qualify for these COVID benefits, the CERB, or even just regular employment insurance. It's an issue, Jordan, that we often face when an employee comes back from a maternity leave or a parental leave and then gets terminated from their employment. Their EI will not cover them during that period post-termination. They've already used all of their EI benefits during the maternity or parental leave. Jordan, unfortunately, I don't have an answer for you, is the honest truth. This is an issue that you should be taking up with your local MP. And this is an issue that should be addressed more through political mechanisms rather than legal mechanisms. There isn't, for example, a challenge that you could bring through our court system, even if it falls under kind of some sort of disability rights issue. That would be the appropriate method and forum and course of action. I think this has to be handled again at the political level by either speaking to your MP, speaking to your provincial member of provincial legislature, and handling the matter that way. That said, I do have to say, I agree with you. I think you have a point. I did speak, and we as a firm, as an employment law firm, spoke with a number of people, particularly those that were coming off maternity leaves that didn't qualify for CERB or EI and were left in the lurch as a result. All right. Question from Andre on Facebook. Should my daughter speak to an employment lawyer if she's been discharged from the military due to vaccination status? Great question, Andre. When it comes to the military, unfortunately, again, it's not an employment law situation. There might be recourse. It is akin, perhaps, to recourse that unionized employees would have in a unionized work environment, in that there may be an agency or a particular, let's call it a union, although in the military circumstance it wouldn't necessarily be called as such, that may be able to assist your daughter here in advancing, either her position in not being vaccinated. For example, maybe there's a particular medical reason why she's not vaccinated, or just with respect to the mandatory vaccination status more generally. Again, she might have some options to file a grievance or to pursue a claim that way. It is not something that an employment lawyer can assist with. Unfortunately, your daughter doesn't fall under typical provincial or even federal, for that matter, employment laws. The military, of course, has its own system, effectively, of justice as well, and that would be her only options. And I regret to say that her options in that respect may be limited, but are certainly worth investigating. All right, just for those of you tuning in, and once again, my name is Alex Lucifero. I'm an employment lawyer with Samfiru Tumarkin, LLP. I manage the firm's Ottawa office, coming to you live today from Ottawa, Ontario, fielding questions with respect to your workplace issues. Any questions, any concerns you have about what's going on at work, or if you're just curious about a situation, maybe you're not dealing with it perhaps, but if you're wondering about severance, or about what happens if you're terminated because of a vaccination policy, as Andre asked on behalf of his daughter, go ahead and ask your question, leave it in the comments or in the question field, and I promise you I will get to it. We are going to be live on air here for the next 15 minutes, so now is the time to get your question in and get it answered. Let us keep going with the questions. Bubba Wilson, great name, asks, as a seasonal worker, if I go to work for someone else and don't go back, do I get severance pay? Bubba, the short answer is no, in the sense that, well, if you find another job and then refuse the call back to work, if you are presuming you are called back next season, that is akin to a resignation. You are effectively walking away from that job and starting another job and moving on. You do not get severance pay if you resign from your employment. Now, that said, if you're a seasonal employee rather, and you are not called back to work at the start of your season, well, at that point in time, you can treat that non-callback as a termination, in which case you would be owed severance. So in other words, if it is the employer that effectively ends the relationship by not calling you back to work, listen, that's a termination, straightforward. You would definitely be owed severance in a case like that. But if it is you who is initiating the end of the relationship, again, by finding another job and refusing the call back to work at the start of the season, well, again, there's no question that is a resignation and you wouldn't be owed severance in a case like that. Interesting question, though, Bubba Wilson, and I appreciate you asking. It's not obvious to a lot of people out there. All right, Belinda asks, can my employer change my contract without my permission? Great question. If they do it for multiple staff across the board, they want to change our hours and commissions. Belinda, this is actually the issue I wanted to discuss today, and it's to do with changes to the terms of employment. To answer your question briefly, Belinda, no, your employer can't change the terms of your employment. They can't change your contract without your permission. In other words, without your consent. If they're making positive changes to your contract, right? If you're getting a raise or if your hours are getting better, whatever better looks like for you, well, then great. By all means, they would obviously have your consent. But if your employer is making negative changes to the terms of your employment, if they're changing your commission structure and that's going to impact you negatively financially, or if they're changing your hours for the worse, Well, that's a problem. You don't have to accept a negative change like that. You can actually reject the change and potentially either force your employer to back down, or, worst comes to worst, you can treat your employment as terminated as a result of those changes. It's what we call a constructive dismissal. It basically, what a constructive dismissal is it's a breach of contract. So by changing the terms of your contract in a negative way, Belinda, what your employer is doing is basically breaching your employment contract. It doesn't even have to be a written contract. It could just be an implied contract of employment. It could be just the existing terms of employment as they exist right now, implicitly, without anything necessarily written down. Now, as a small caveat to that, Belinda, you can only act on a significant change. So if they're changing your commission structure, but it's only going to result in a change over the course of a year of a couple of $100s, there might not be enough there to really act on. But if the change is a significant one, then you can definitely reject that change. And I would suggest that any significant change that's affecting you negatively, that you do reject. That's how you preserve your workplace rights as an employee who's being subject to changes that they don't want. I would also strongly suggest, Belinda, before you sign anything with your employer, before things get too heated, speak with one of our employment lawyers. Give us a call, send us an email. In the email that you send us, describe your situation in a little more detail. It's strictly confidential. Give us a little bit of meat that we can sink our teeth into what's actually happening on the ground, and we can properly advise you on what your options are and what your best option is, most importantly. Again, if you want to visit our website, employmentlawyer.ca. If you want to email us, help@employmentlawyer.ca, help@employmentlawyer.ca is where to contact us. Great question, Belinda. It's a very important topic. It should be known out there. And again, to remind everybody, if your employment is if the terms of your employment are changing in a negative way, if your hours are being changed significantly, if your pay is being reduced, if your employer is temporarily laying you off and you've never been temporarily laid off before, if you're being demoted from your position. I had an individual that I helped most recently who was a sales executive for a good 10 years and was demoted, even though it wasn't really a demotion on paper, but his position was changed to that of an account manager. And there was a really big difference in those two positions, even though it might not be obvious. It was effectively a demotion within the company ranks. That is a constructive dismissal. I actually ended up getting that employee a significant severance package strictly on the basis that his position changed. Do not assume that your employer can change your employment willy-nilly. You have the right to say no in your employment, and oftentimes the right call is to say no. Otherwise, your employer will simply take advantage of you. All right, Mark is up next. Mark asked, what happens to workplace mandates if the government pulls back on COVID restrictions? Can employers still require vaccination? Mark, excellent question, very topical question. We are dealing with this in Ontario and again across Canada as we speak. I can tell you this, Mark. Employers who let employees go on the basis of these vaccination policies took on a high degree of risk and a high degree of liability in having to pay these employees severance. And I think that is only now going to be confirmed with, as you mentioned, the government relaxing restrictions, ending mandates. In Ontario, at least, those mandates are supposed to be ending on March 1st. In other provinces, such as Alberta, I believe they've ended, a lot of restrictions have ended already. I think that just goes to show that there's going to be no question that those employees that were let go as a result of their vaccination status are going to be owed severance. That is ultimately the recourse, Mark, that these employees are going to have. It is possible, and even dare I say likely, that a good number of employers will want to keep these mandates. I don't necessarily agree with that. I think the game with respect to COVID-19 has changed significantly as a result of Omicron, and that these vaccination policies don't necessarily have the health and safety effect that they should be having in workplaces and in public spaces in general. But that said, the reality, Mark, is that if you've lost your job as a result of these mandates, or if you're going to be losing your job as a result of a vaccination policy, It's very difficult to save someone's job in that respect, particularly if you're a non-unionized employee. But the recourse is going to be one of severance. You are going to be owed severance as an employee who's been let go as a result of a vaccination policy, just as any other employee would be owed severance if they were let go in the ordinary circumstances of, let's say, a restructuring, or in what we call a termination without cause, which was a termination for no particular reason at all. So, Mark, ultimately, the main recourse is going to be one of severance. If an employer wants to impose a vaccination policy, there's nothing inherently stopping them from doing so at the moment. And so you can lose your job over that issue, but you would certainly be owed severance if that were to happen. All right. Tony asks, how much weight, in quotations, do you or should you give language contained in your hiring letter that limits severance amounts paid if terminated without cause? Tony, another excellent question. Guys, I love the questions coming through today. They are extremely pertinent and extremely important. Again, for those of you just tuning in and just listening, these are excellent, excellent questions. And Tony, appreciate you asking, because the information I give here will help a lot of other people out in answering the question, not just yourself. Now, to answer the question, Tony, with respect to termination language in employment contracts, I think you have to give them, at least off the bat, a decent amount of weight, in that there is a chance that that language may actually be enforceable. And so you should know when you're signing a contract whether the termination language that's in there that might limit your severance if one day you are let go, you should know whether or not that language actually does the trick of limiting your severance entitlements. You should know whether it's enforceable or not. And so if you've been, if you've been given a job offer and you look through it and it's 3 or 4 pages long and there's a paragraph in there that's titled termination, and it says, in the event that we let you go, we'll pay you X, Y, or Z, you'll want to know before you sign that contract whether that language is enforceable or not. And the way to do that is to make sure you have your employment contracts reviewed by an employment lawyer such as myself. It is an excellent, excellent thing to do at the start of an employment relationship so that you know exactly what you're signing up for. Some of these employment contracts, and more nowadays, these contracts have a lot of legalese in them, a lot of terms that you don't necessarily understand as a layperson, and that's why it's important to have an employment lawyer explain them. Now, there's a second side to that story, Tony, which is if you are let go from your job and your employer tells you, and they might reference it in the termination letter, or they might tell it to you verbally. But if they say, hey, employee, you actually signed an employment contract that limits your employee to X, Y, limits your severance, rather, your termination pay to X, Y, or Z. And so, here you go. That's what we're going to pay you. You just have to sign here. At that point, Tony, you should not be taking your employer's word for it. There is a decent possibility that the language in an employment contract, particularly an employment contract that's signed, a couple of years ago or more, meaning if your contract is 1 or 2 years old or older, there is a very good chance that the language in that contract is not enforceable. And so if you are let go and offered severance, and that severance is tied to what your employment contract says, do not assume that what your contract says is correct. Again, the advice is make sure you speak with an employment lawyer before you sign off on a severance package. Chances are, if your contract is older than 2 years or more, the chances are the language in there is not enforceable, and therefore the severance that your employer is offering you is significantly less than what it should be. And that's a general point with respect to severance. Do not assume that what your employer is offering you is correct. Do not assume that they are perfectly in line with what the law provides for. Oftentimes, and I would say the vast majority of times, what your employer offers you as severance is far less than what you're actually entitled to. Your severance entitlements are based on your age, your position, and your years of service. They can be as much as 24 months of pay. That's 2 years of pay. Now, that's for older employees or for longer service employees, but still, odds are the severance that's being offered by your employer is insufficient. Do not sign off on a severance offer without speaking to an employment lawyer first, or as a first point of contact. Again, pocketemploymentlawyer.ca is where you can assess your severance offer initially, and then you can speak with an employment lawyer after that. All right. Let's keep it moving, guys. We've got about 5 minutes left. Is it enough to consider a single incident of constructive dismissal for someone who committed theft over $500? It's, a theft situation isn't a constructive dismissal. It may very well be a termination for cause. A termination for cause is when the employer has the right to terminate an employee without any severance whatsoever. So you are literally kicked out the door that day that you are terminated, and all you get is your last day of pay and maybe some vacation pay, but absolutely zero severance. Now, terminations for cause are reserved for the worst of the worst offenses. So we are talking kind of the most egregious things that you can do in the employment context. A little bit of a history of bad performance isn't enough to establish cause for termination. It has to be much, much more than that. Now, that said, and this is VS 2015 that asks this question, a theft, even if it's $500, which is still a significant amount of money, by the way, would be considered cause for termination. It's arguable that even a theft of $100 would be considered cause for termination. There are actually some cases that say even a minor theft would be considered cause. And so in a case like that, theft is definitely something that crosses the line there, in which case an employee wouldn't be owed severance. That said, I can tell you the vast majority of cases we see where cause is alleged, again, a lot of times it's due to poor performance, or a lot of times there's some degree of misconduct there. Maybe you as an employee, got into an argument with someone. Those are not instances of cause. And even where an employer alleges cause in a situation like that, almost always we are able to obtain severance for those employees that have been wrongfully dismissed and not offered any severance. So if you've been let go for cause, or alternatively, if you're an employer and you're thinking of letting an employee go for cause, make sure you get legal advice first. Cause is a very, very crucial issue. Literally tens and tens, if not hundreds of thousands of dollars can hinge on the fact of whether cause exists or not. And so it's a decision that you want to get right. All right, we'll have to leave it there, folks. Apologies to those of you that I maybe didn't get to, but that's okay. I'm sure we have another session coming up shortly, as you see there, on Monday with my colleague and friend Luke Serta. He'll be answering your questions on February 28th at 3 p.m. Eastern Standard Time. Until then, thank you all for tuning in. I hope you found the information informative. Once again, my name is Alex Lucifero, partner with Samfiru, Tumarkin LLP, an employment lawyer. Until next time, I wish you all a great rest of the week and a great weekend. See you next week.